Hey, welcome again to Employment Hour in 30. John Scholes, Lior Samfiru. We've been doing this show for a long time. You have learned lots of things, but once in a while, I think it's good just to reset and give people who are new to the show an idea of what we do here for the next half hour, pal. What do you think?
Well, we spend so much time at work. We spend more time working than we do anything else. And our laws are very good in protecting us when it comes to workplace rights. But the problem is a lot of people don't know what their rights are, don't know what the law says, don't know what protections they have. Well, that's important information to have. So we want to use this forum right here to educate people, to inform people about those rights so that when you go to work and you're facing a problem, you know what to do. If something bad happened, you lost your job changed, what does that mean? You need to know what that is. So we talk about that on this show every week. We talk about it on radio every week so that we arm people with that information. It's about your rights, your laws. So stay tuned. We talk about that every week.
EmploymentHourTV.ca, by the way, is a good resource to find where you can catch those radio shows, which I think we're into year 7 by now. So we've been doing a lot of those. We'll get to some phone calls from the show in just a bit. But we always start the show, other than what you just did, with a segment, a success story, a week that was, if you want. What do you got?
Yeah, you know, John, we talk often, we've talked often on the show before about workplace harassment. And we talked what it means if you're being mistreated. You know, I've told people you have to go and you speak with HR, speak with someone, let them investigate, make sure that they take steps to fix the problem. But we haven't spoken before about that from the perspective of the person who has a complaint filed against them. Well, I got a call last week from a gentleman who had a coworker file a harassment complaint. Actually, it was a sexual harassment complaint against him. And he had no idea about it. He didn't know anything about it. How did he find out? He found out because he was called into a meeting, and in the meeting they said, this harassment complaint filed against you, what do you have to say? He said, I don't know anything about it, never did it. Well, we don't believe you. Here's your letter of termination.
Wow.
Was terminated right there on the spot. Well, here's the problem with that. The problem with that is that, as our regular viewers know, an employer has to investigate. And coming into a meeting with the termination letter drafted is not an investigation. You're not letting the person an opportunity to tell their side of the story, to explain why, in fact, they're innocent, why they didn't do what they're alleged. An employer has an obligation to investigate. That means being neutral, giving everyone an opportunity to speak. You can't make up your mind. Now, this person says, no, I didn't do it. The company clearly did not investigate. So to me, this is a wrongful dismissal. Company can't jump into conclusions. Company has to investigate, it has to take it seriously, has to speak with whatever people it needs to speak, and then take measures to fix the problem. But it can't skip steps in the process. And if as a result of that, you're being told that you're going to lose your job, there's going to be consequences against you, even though the company didn't investigate, that is wrong. That could be a human rights violation. That could be a wrongful dismissal. And in this case, John, this company is going to have to pay.
Once he's been let go and he gets paid the proper severance, can they then go back and investigate the claim? Because I know he's no longer working there, but I mean, this is a pretty serious allegation.
It is a serious allegation, but if it seems like they decided to impose punishment before they've actually decided whether punishment should be imposed. So it doesn't work that way. If you're going to punish someone, that's fine. Sometimes you have to, but you need to be sure that there's cause for punishment. There's cause for discipline. You can make up your mind, punish, and then see if you were right retroactively. It doesn't work that way. So this company did it all backwards, and because of that, they're going to have to pay severance, potentially human rights damages. And the message here is very clear to employers, to employees. Companies have to investigate. Companies have to take measures to fix the problems, but they can't make decisions without that investigation.
Reaching out is simple. 1-855-821-5900. EmploymentHourTV.ca is the resource, like I mentioned off the top, to catch the radio show, which we're all over the place for many years. We do the show. We get a lot of interesting calls, and we like to play them back on this show. And I know you want to dissect them, Lior. So we'll get to our first call for the day.
My wife has been working for the software developing company for about 7 years now. Project coordinator. She's 37. And right now she's on the maternity leave. She's about to go back to work in about 3 months, and she heard that they're letting some people go. So she's worried that they're going to let her go. And she told me that people have been getting very small amount for severance. If they're doing restructuring, they can basically let her go. How does it work?
The key word there is restructuring.
The key is restructuring, and the other key words are maternity leave. Because when you're on maternity leave, you have the right to your job back. It's very important. Company can decide they don't want to just hire you back or they want to keep your replacement. That's illegal. Now, the exception to that is if the decision to let you go has nothing to do with maternity leave. Maybe it's a restructuring, cost cutting. They shut down the department. Okay. So the first thing I'd want to do in this situation is investigate how sure are we that this is a legitimate legitimate termination decision? How sure are we that they're not using the term restructuring to hide the fact that they're letting her go because she's on maternity leave? In other words, is this legal? If it is not legal, then it's a human rights violation. It's a violation of the Employment Standards Act. There's going to be significant repercussions. If it is legal, then it's simply a matter of severance. If they're legitimately restructuring, legitimately they don't have a job available, they have to pay your severance. So rather than tell you how much severance, let's plug that in to the severancepaycalculator.com website, and we can see on the screen right now what that would look like. So she's been there for 7 years, project coordinator, 37 years old. Severance pay calculator correctly says she's owed 6 to 8 months pay. So if this is a legitimate termination, as we see on the screen, 6 to 8 months pay is what they would owe her. Anything less than that would be a wrongful dismissal. So it's about severance, it's about human rights. All those things have to be considered.
Does a bit of a sidebar, does the same thing apply if during her maternity leave they brought someone in to fill her position because they got to run the business? They like the new person better. What do? Can they keep her?
They can't keep
or them.
They cannot keep that person, and it happens often. You know, we replace the person while they're on mat leave. My gosh, this new person, we like them better. They do a better job. Fair enough, but you can't do that. Hey, if you can find a way to keep both of them, wonderful. Otherwise, you have to bring back the person from maternity leave, from parental leave. Same thing applies to fathers, by the way. If you decide you're going to keep the replacement, that is a human rights violation with a cherry on top. Again,
employmenthourtv.ca is the resource to find those radio shows. Phone call number 2 right now.
My good friend works for a company, is a salaried employee working 40 hours a week, makes a commission. It's a sales position, and their employer was just recently calling a meeting saying, we're going to give you this great opportunity. You can work as much as you want and not be entitled to any time and a half beyond the 40-hour work week. And it just seems really kind of like they're trying to pull one over on the employees. I thought I'd call to see if that sounded kosher to you.
Well, can I have that? I can work as much as I want and not get paid overtime. Where do I sign up? Well, obviously that's not legal. You have to get paid overtime. Now, with respect to salespeople, there's an exemption to overtime, and that is for salespeople that are on the road all the time.
Because you can't calculate where they are?
You can't really monitor what they do, how long they work. So if you work from the office or work from home for that matter, then yes, you can. You have to get overtime. So to be clear, overtime is paid based on 44 hours a week. Anything over that is time and a half. Okay. And same thing applies to hourly, applies to salary, applies to commission. Whatever you earn in a week, time and a half has to be paid over 44 hours a week. So what this company is doing, unless of course this person is on the road all the time, is illegal. It's a violation of the Employment Standards Act. So what can she do? Call me. Obviously, go to the Ministry of Labor if you need to. But you have to get paid overtime if you work more than 44 hours a week. There's no exceptions unless, of course, you're on the road all the time.
Talk a lot about topics on this TV show and the radio show, of course. We like to cherry pick one and get to 3 or 4 or 5 answers and topics when it comes to this particular thing for the week. This week, it's a good one. When you've been let go from your job without even realizing it, that actually happens.
It happens. We're going to give examples. Obviously, a regular termination, and you're called into a meeting, you're handed a letter, sorry, today's your last day, and you know it. It says so on paper, they've told you. But there are certain circumstances where the company doesn't let you go, but the law considers you as having been terminated. So we want to talk about situations where you may not actually be being told, you're not told that you're let go, but the law says, no, wait a second, you have now the right to treat yourself as being terminated, get compensation, get severance, and move on. So those are important things for you to know.
The first one may shock people, and that is you've been put on a temporary layoff.
A temporary layoff. So people have heard that. A lot of people have been on a temporary layoff. The idea being, no, we're not letting you go. We're just suspending, if you will, your employment for a period of time, and we'll call you back. Yeah, no kidding. No kidding. Well, here's the thing, John. A temporary layoff is a termination. Right. The law comes in and says, no, if you've been laid off temporarily, you can treat that as a termination. The company doesn't have a right to do that. They can't put you on ice for 6 weeks and then call you back. So what happens if you've been laid off temporarily? You can accept it and continue working and be called back, hopefully. Or you say, no, I'm not accepting. I'm treating this as a termination because the law gives me that right. And get your severance. If you accept it, you give them the right to do it again. That is a problem. So remember, a temporary layoff in most cases is a termination.
When you've been let go with not even realizing it. Point number 2, your employer changes the terms of your employment. This is a rather wide umbrella.
That is a very wide umbrella. We refer to this as a constructive dismissal. Yep. And a constructive dismissal happens when the terms of your employment change. Change in jobs, change in pay, maybe you've been demoted, relocated, your compensation structure has been changed. All those types of changes, and by the way, one of them is enough, you don't have to have all of them, can be a constructive dismissal. So the law says, no, by them changing the terms of your employment, it's as if they let you go. It's as if you now can treat that as a termination and get your severance. Constructive dismissal happens often. And as I said before, if you accept that change, you accept that demotion or the pay cut, you give the company the right to do it again and again and again. You really don't want to do that.
How about the third one? That is you're put on an unpaid, I stress unpaid suspension.
Unpaid suspension. So maybe you did something wrong and the company says, you know what, we're going to put you on an unpaid suspension for the next few days.
Right.
That is not something the company has a right to do. Company does have the right in most cases to do a paid suspension if it's justified. They can't just do it because they want to. But an unpaid suspension as a disciplinary measure is illegal. It's also a constructive dismissal. So if you've been suspended without pay, you arguably now have the right to treat that as a termination. Same rule applies though. If you've let the company do that in the past, if they've suspended you with pay in the past and you came back to work, now you've given them the right to do it again. So the first time the company suspends you without pay, stop and think about it. Are you going to accept that, or are you going to treat that as a termination? Because the company does not have a right to do it.
You have questions about any of these points or more, help at employmentlawyer.ca is the email address to reach out. But we are talking now about the times you've been let go from your job. You don't even realize it. Next one on the list, Lior, is the company you're working for is being sold.
A sale of a business, when the company sells its business, regardless of whether or not you're offered a job with the buyer, is a termination. So you can treat the sale itself, the fact that your employer is going to change, as a termination. Now, you don't have to. In some situations, the new company is going to offer you a job to continue working, and then that's fine. And then you're disregarding that termination and your service continues with the buyer. But you can treat that sale of a business, if you want to, as a termination and get severance. So if a business is sold, you always have to think, am I going to accept the offer? Am I not going to accept the offer and treat that as a termination? If you're going to treat that as a termination, before you do that, before you tell the company, I want you to talk to me first because we need to do this correctly. Right. But a sale of a business does result in a termination if you want it to.
We talked about this off the top, and that is a harassment topic we had with the week that was. And this one is right in there as well. The times you've been let go from your job and not realizing it. You're in the middle of, or you're dealing with a poisoned work environment. So
we all have the right to work in a healthy, supportive work environment. It's a very basic and it's a very important right that we have. So what happens if that right gets violated? Instead of a supportive work environment, it's now a poisoned work environment. Instead of a healthy work environment, it's now a toxic work environment. Well, we can treat that situation that's been created by the company as a termination. I don't have to continue working in a bad environment. I don't have to be harassed, mistreated, yelled at, etc. The fact that I have to go to work and deal with that gives me the right to treat that as a termination. So a poisoned work environment, workplace harassment, gives you, in many cases, the right to say, no, I'm not going to take this. I'm going to leave and get my compensation. The company essentially has terminated your employment. It's another form of constructive dismissal. And as I said before, if you are in that situation, if you're being harassed, mistreated, you're dealing with the poisoned work environment, before you do anything, before you quit, before you say, I'm out of here and pack up your office, call me. Let's talk about how to do that smartly so we don't compromise your rights and entitlements, but that is a termination in many cases. Again, 1-855-821-5900 is the number. We'll put it up on the screen several times during this half hour. The last point we'll get to, and that's times you've been let go from your job, not even realizing it. You're sick or you're injured and you can't return to work. So if you're off work for medical reasons, whether it's an injury or a serious condition, if you know that you can't come back to work, and if you have a doctor confirming that physically, as a result of your medical condition, you can't come back to work, you can treat that situation as a termination. We refer to that as a frustration of contract, and you get your severance. Now, you may not get your full severance, you may get a portion of your severance, but that is something that you can do if, in fact, number one, you're sick, you've been off work for a while, and it's not likely that you're going to be able to come back to work. You can force the issue. You can treat that as a termination, even though the company hasn't done it or even thought about it. You can treat that as a termination. Again, if that happens, I want you to reach out to me. We're going to stay right here. Hopefully you stay right there. We'll take a short break, and when we come back, we'll get into the severance pay calculator. This you don't want to miss. That's on the way right here on Employment Hour in 30.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless. but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, welcome back to Employment Hour in 30. Again, John Scholes, Lior Samfiru, talking about your workplace rights, keeping you safe in that workplace where you spend thousands of hours every year. So you got to know about it. Severance Pay Calculator, an amazing tool, can be found right now. You can sit there and plug away as we talk about it. Severancepaycalculator.com. We'll do an example, but first, break it down.
Yeah, actually, once we have people get their smartphone, get your laptop, get your desktop, go to severancepaycalculator.com and check it out as we talk about it, because it's such an important tool, but it's so easy to use. Severancepaycalculator.com. If you lost your job, the easiest place to go to, the fastest place to go to if you want to know how much you're actually owed.
Right.
If you're looking at that severance letter, and by the way, that severance letter could be 5, 6, even 10 pages long oftentimes, and there's an offer there, and you don't know if it's appropriate, is something missing? Well, don't wonder anymore. Severancepaycalculator.com takes seconds. You answer 3 questions: your age, your position, and the length of your employment, and you're done. You find out whether you're owed 6 months pay, 24 months pay, 18 weeks pay, whatever it is, you can find out. It's easy, it's anonymous, it's free, there's no strings attached. I wanted to make sure that people have access to that information, John. So check it out. Go grab your phone right now, put in your information right now to see how much you're owed. Severancepaycalculator.com.
Again, contact button at the bottom. There's also an employer mode, so if you're an employer, you want to do the right thing, not get into hot water later on for gypping someone off for their severance. You can do it right there as well and find out how much you're actually owing a soon-to-be ex-employee. But it's always best to give an example of how it works, so I'm going to run this one by Lior again, severancepaycalculator.com. 58-year-old Carolyn was hired as a supervisor at a retail chain after the previous supervisor left for another job. 9 months later, Carolyn was let go because the previous employee wanted her job back. Nice. Is that legal, and is she owed more than 2 weeks' pay?
Well, let's be very clear. It's not nice.
No.
It's not a nice thing to do. But is it legal? The answer is yes.
No.
The company is allowed to let you go because they want to have someone else in the position. It's not a nice thing to do. We can even talk about ethics. But from a legal standpoint, the company can do that as long, of course, as what? As long as?
Pay proper severance.
As long as they pay proper severance. That's what they have to do. So this situation, as unfair as it may seem to Carolyn, comes down to severance. So she needs to know how much she's owed. So severancepaycalculator.com.
Love it.
Let's plug that information and let's see how much she's owed. So she's in a supervisor role. She's only been there for 9 months, just 9 months. That's not a very long period of time, 58 years old. So for her, even after 9 months, she's owed anywhere from 3 to 6 months pay.
Wow.
Now, depending on her compensation level, that could be tens of thousands of dollars, again, depending on how much she's earning. So we can see that on the screen. And it's important to understand that because even as a short service employee, 9 months, some may say, oh, she gets a week's pay. If she's really lucky, she gets 2 weeks' pay. Then she's really laughing. No, except short service employees you have to understand, are treated disproportionately better. They get more severance, not less severance. So 3 to 6 months pay, even after only 9 months of employment. That's why it's so important to go to severancepaycalculator.com. And if you don't think that you're owed that much, check it out yourself. I bet you that you are.
We have been talking about this for years on the radio show. EmploymentHourTV.ca is the place to find a station near you. Please catch them, listen to the podcast, listen to all the shows. There's so much information there. And a bevy of fine phone calls, which we play back in this show. And I know you like to dissect them. We'll get to another call.
I've been with the company for 8 years, and I've never had any issues. I've had great reviews. Now, what's happened is that I actually hurt myself in a WSIB claim while at work. Now, in the past 2 weeks, I have gotten 3 written warnings, and they're trying to basically kick me out because I can not really do my job anymore. So I'm looking for advice.
Okay, how do you handle that?
So here's the situation. You're a good employee. Everyone likes you. You get great reviews. Everyone says you did a good job. You get pay raises. And all of a sudden, things start to go south. Now you can't do anything right. Yeah. You get mistreated. You get warnings.
Maybe you get pariah.
Yeah, you're a pariah. Performance improvement plan. And what's changed? Well, the only thing that's changed, I guess, in this situation is that he got injured and that he had the audacity to apply to the WSIB. Well, here's the thing, John. It's illegal. You cannot mistreat someone because they were injured. You cannot mistreat someone because they applied to WSIB. Now, companies may not be happy that you apply to WSIB because it could increase their premiums. But it doesn't matter. They cannot mistreat you. And if they do, that's a human rights violation. That's a violation of the Employment Standards Act. That's a violation of the Workplace Safety Act. It's a violation of many things. It's illegal. They cannot do that. It's wrong. So for this person, he could potentially treat that situation, again, as a violation of his rights. He could treat that as a constructive dismissal. So I would try to see if he can resolve it internally. Maybe speak with HR, give him an opportunity to address this problem. If he can't do that, or if the company won't fix the problem, I want him to call me. You cannot be mistreated, warned, suspended, be treated as a pariah, as you said, because you were injured. Can't do that.
How working notice can impact your severance pay. We will get to that after a short break. Stick around, 1-855-821-5900 and help at employmentlawyer.ca to reach out as well. It's Employment Hour in 30. Back in a sec.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, welcome back. Employment Hour in 30. A resource for you to find more about this show and the other show. Employmenthourtv.ca, pardon me, is a place where you can find a list of stations where you can catch the radio show. Always a good thing to do. We are into our 7th year doing that show, informing people, enlightening people, giving them the information they need about their workplace, and you give it back through the phone calls, which we play on this show, and you comment on it, Lior. We'll get to another one.
My wife has been laid off. She's a billing investigator, 19 years. But they gave her a year's notice, and they've done that to a lot of employees. Now, once she leaves work, is she entitled to severance on top of whatever she's supposed to get?
Or the combination thereof, right?
Very, very important question, and something that people often misunderstand, and even employers do, so we should talk about that. We talked about that. We've said this already 5 times on the show today. If you're let go, you're owed severance. Well, one of the ways the company can pay severance is actually to give you advance notice of your termination. So hypothetically speaking, if someone is owed 6 months severance, they could get 6 months notice instead of that severance. We call that working notice of termination. So if this person is getting 12 months notice, that 12 months counts towards her termination entitlements. But we want to know if that's enough, because if 12 months is not enough, she's owed more severance on the back end, at the back end of it, on top of it. So rather than me tell you how much she's owed, let's plug it in again to the severancepaycalculator.com website. So in a technical role, after 19 years of service, I picked an age, let's say she's 55 years old, and we know she was offered 12 months notice. Right. Severance notice, the same thing. Except Severance Calculator correctly said that she's owed 18 months. You see that on the screen, 18 months. She was offered 12 months as notice, but she really should have been offered 18 months. So what does this mean? Well, unless my math is off, she's owed another 6 months of pay. Right. So they gave her 12 months notice. That counts towards her 18 months. They have to pay the difference, which in this case is another 6 months pay at the end of it. So for you out there, if you lose your job and the company gives you advance notice in writing has to be, of the termination of your employment, that notice, that period of time counts towards your severance. You may not want it to, you may think it's unfair, but it does. But you may still be owed severance at the back end of it You can go to severancepaycalculator.com for that as well, or always call me as well.
And that remaining 6 months on the back end, that has to include whatever bonuses, benefits, car allowance, all that stuff as well.
Absolutely.
Like if she was working.
Like if you're working. When it comes to severance generally, doesn't matter how you get it paid, it has to include all components of your compensation. So the company is not going to forget about salary, of course. But what about bonus, benefits, pension contributions, car allowance? All those things have to be included. If you want to know if something needs to be included, you simply ask yourself, would I have received it if I was still working? If the answer is yes, I would have, then it has to be included as part of your severance.
Another place to go to help you through your working journey is terminationquestions.com. Ask your questions. They get answered by Lior, a member of his team, and you'll have your answers. I'll get to one here. It says, again, from terminationquestions.com. I was cut off LTD, my long-term disability, by the insurance company because they deemed that I am well enough to return to work. There is no medical evidence to support that. Now, my boss will fire me if I don't go back to work. Would I be owed termination pay?
Yeah, and we deal with this often. And you also host a TV show and a radio show with my colleague, Tumarkin, dealing with disability issues. So disability issues come in usually in one of two ways. Either the disability insurer, the long-term disability insurer, cuts you off because they say you should be going back to work and you disagree with that. Or your employer says, we don't think that's right. Your employer says, you should be coming back to work. So let's talk about that. If you're not able to come back to work, the company can't make you. If you have a doctor saying you cannot come to work, that you are unable to work for medical reasons, that's enough. That's all that you need. The company can't decide on its own if you can work. They can't say, well, the insurance company is telling us something. It doesn't matter what the insurance company is telling the employer. It does not matter. What matters is what your doctor is saying. So if you're a doctor, you have a doctor's note saying, this person is my patient. This person cannot work.
That's gospel.
That's it. That's gospel. It's done. It's over. The company cannot say, well, we don't think that's right. You don't seem that sick, or the insurance company is saying differently. They have to allow you the time off work. They can't fire you. They can't punish you. They can't do any of that. If they do that, call me. If your insurance company calls you and tells you you're going to be cut off before the doctor says, your doctor says you should be cut off, call me as well. Let's talk about that. That's illegal. There's ways to resolve that and resolve it quickly. Your doctor, ultimately, the analysis begins and ends with your doctor.
Going to squeeze another one here quickly. I think we have time. Again, terminationquestions.com says, I missed my sales goal by 2% last year, despite my best efforts during a tough business year. Now I'm on a performance improvement plan. If I don't meet targets within 6 months, they will consider letting me go. After 6 years of hard work, I don't think this is fair at all.
No, it's not fair. But here's the other thing is, if you're doing your best, you're trying your best, you're working hard, even if you don't meet your sales target, it does not mean you can be let go for a cause. Now, you can be let go with severance because generally the company can let you go at any time as long as they pay severance, but you cannot be let go without that severance. So you may have missed the goals and maybe you should have hit them. What I want this person to do is this. I want them to tell their employer in writing, always in writing, what you've been doing to try to improve, what issues you've been having or obstacles you've been facing in meeting those targets, telling them you're working hard to get better. If they decide to let you go, they're going to have to pay severance. No two ways about it. The fact that you've been put on a performance improvement plan does not mean you can be let go for cause. The fact that you've been warned doesn't mean you can be let go for cause. To be let go for cause, essentially the company would have to show that you're, I guess, going out of your way to do a bad job. You're slacking off. You're not doing what you're supposed to, rather than, I did my best, it didn't work. That's not cause, and most companies pull the trigger on a termination for cause well before they should, John.
And I know we've seen cases before where companies, especially with salespeople, will set such unrealistic sales targets. They're kind of already working on pushing them out the door for that very reason.
Exactly.
Right?
Exactly. And if you're in that situation, say that to your employer. If they've imposed targets that you know you won't be able to meet, say so. Say to them, tell them, I don't think I'm going to be able to meet them, and here's why. I'm going to do my best, because later on, when it turns out you were right, you cannot be punished because you told them. You set the stage. You have some credibility there. So don't be silent. If the company puts targets, thresholds, milestones that you're going to not be able to meet, say so in advance. And if you do that, you will not be fired for cause.
A lot of good stuff this week. We are going to wrap it up for now. You want to reach out and contact Simple Help at employmentlawyer.ca, employmenthourtv.ca. That's where I mentioned to find the radio shows. Good old phone call, 1-855-821-5900. Hope you enjoyed the show. We will catch you next week right here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.